This is file 24-21908-FH, People of State of Michigan versus Timothy Lee Redis. We are here today for a hearing on a arraignment on a request and warrant for probation violation. We are proceeding today by video conference. Sir, you are Timothy Lee Redis?
Yes, sir.
Mr. Redis, have you received a copy of the request and warrant for probation violation?
Yes, sir.
That warrant alleges that you violated the terms of your probation by being arrested for domestic violence and also by pleading guilty to disorderly conduct on August 1st, 2025. You, in this case, were previously convicted of domestic violence and or knowingly assaulting a pregnant individual. And the maximum penalty for that offense up to 5 years in prison and or a $5,000 fine. You do have the right to be represented by an attorney today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes.
Would you like to be represented by an attorney?
I just want this to go by as quick as possible, so whichever is best, to be honest.
Well, that doesn't really answer my question. I need to know if you want to be represented by an attorney or not. We have one here today that you can talk to right now.
Yes, I would like to speak to them, please.
Okay. Do you have the ability to pay for your own attorney?
I do not.
Okay. I'm going to put you in a breakout session with Ms. Underwood from the public defender's office. If you'll give me just about 10 seconds here.
Yes, sir.
Okay, Mr. Glazer, are you ready to proceed with Mr. Stump?
Yes, I am, Your Honor. Well, did you get a plea sent into you by Isaac today?
I do not have anything about it.
I just talked to him about, well, just about 5 minutes ago, he's going to send one in. I can enter the plea without the form.
Do we have a signed advice of rights form?
I don't know. He's in jail.
You can call the jail next to take. Mr. Winter, are you ready to proceed with Mr. Pinkelman?
I am, Your Honor.
Thank you.
Hey, Jordan. This thing says it wants me to bookmark. Yeah, put this on.
This is file 24-22212-FH, State of Michigan versus Brent Pinkelman. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Ms. McClure.
Good morning, Your Honor. Phoebe McClure on behalf of the people, filling in for prosecutor of record Jackie Wise.
Good morning, Your Honor. Peter Winter appearing on behalf of Mr. Pinkelman. I'm stepping in for Mr. Amadeo, the attorney of record.
Okay, and Mr. Winter, do you know where we stand with Mr. Pinkelman's case today?
Your Honor, I believe that that we are going to ask the court to adjourn this pretrial again. I know that there have been a number of adjournments, but I believe it's both the Attorney General's office and Mr. Amadeo are going to ask the court to set this for trial, but push it out because of the attorney's schedules, Your Honor.
Okay.
And Your Honor, the information I was given was that it was, both attorneys were requesting a trial to be set in May, given both of their schedules, and they were going to ask if Mr. Pinkelman would waive his right to a speedy trial today. If he's not willing to do that without Mr. Amadeo, then we would just ask that it be set for another pretrial for that to happen.
Okay.
Your Honor, on behalf of Mr. Pinkelman, I haven't spoken to him, but I know that typically Mr. Amadeo will waive that right to a speedy trial, so that shouldn't be a problem.
And just for the record, Mr. Pinkelman is not in custody, waiving that right.
Yes, he's out on bond, Your Honor, and he's made all of his court appearances to date, Your Honor. And I believe he's in the gallery on Zoom.
Okay, and I show an order for competency evaluation that was done in district court, but I don't see any resolution of that in my file. Are either of you aware of that status?
Yes, Your Honor, on the May 28th date when we were here, Mr. Amadeo said he was withdrawing that request. Yes, that's what it was. He was withdrawing his request for a competency review and will not be asking for one.
Sergio, can you grab the red folder from Francis?
And if we are setting it for trial in May, could we also have a pre-trial in maybe November or December just to track this before the end of the year?
All right, what I would like to do is set it for a pre-trial on September 3rd. And hopefully Mr. Amadeo will be able to be here at that point and we can address the speedy trial issue just to do it with certainty. I'd like to do that with him present. And then can set it for a trial in May at that time, assuming that all goes as planned.
What time would that be, Your Honor? Is that another 8:15?
That would be 8:15, correct. All right, then, is there anything else that we need to address with this case today?
Your Honor, what was the date?
September 3rd.
Okay. And our office can prepare that stipend order.
Thank you, I appreciate that. Okay, if there's nothing else, then Mr. Pinkelman, you can go ahead and log out.
Thank you.
Thank you, Your Honor.
Who do we have? Sorry.
Your Honor, could I have a breakout room with Mr. Winter?
Yeah, 1 second.
Thank you.
You don't see me one time. Let me see if they finish with you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Redis?
Yes, I am, Your Honor. Thank you.
Okay, we're back on the record in file 25-22369-FH. No, I'm sorry, that's the wrong file. Apologize. It's file 24-21908-FH, People versus Timothy Lee Redis. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Redis this morning, Your Honor.
And do you know how Mr. Redis would like to proceed today?
At this time, Your Honor, Mr. Redis, having concluded the matter that is the underlying issue of this violation, wishes to take responsibility and enter a plea today.
All right, Mr. Redis, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
Do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you understand that you have a right to testify if you wanted to testify.
Yes.
How do you plead to these charges that you violated your probation?
I plead guilty, Your Honor.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
So you were sentenced and placed on probation in this case back in December of 2024. Is that correct?
Yes, Your Honor.
And one of the conditions of your probation was that you not violate any criminal laws. Is that correct?
Yes, Your Honor.
And were you at some point arrested for and charged with domestic violence for an assault on a Ms. Nelson?
Yes, Your Honor.
And did you recently resolve that on October 1st, 2025 by pleading guilty to disorderly conduct?
It was August 1st, but yes, Your Honor.
I apologize, August 1st, okay. All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Redis has had full knowledge of his rights, and he has had competent counsel.
Your Honor, I'm sorry to interrupt. What date was Mr. Redis put on probation?
He was sentenced on December 10th, 2024.
Your Honor, he was arrested for this crime on December 6th. This is not a violation. According to the warrant.
The warrant states that the warrant states condition number 1 on the order of probation dated 12/6/2024. That's not when the violation occurred. So that sentence is just when he was placed on probation.
Okay, so you're reading the warrant for the arrest on this violation of probation? Well, let me just ask, Mr. Redis, when were you arrested for the alleged assault on Ms. Nelson?
July 19th.
Of this year?
Yes, sir.
Okay. So clearly he was on probation at that time, and there's an adequate factual basis. So
Your Honor, but the crime took place before he was on probation.
he was placed on probation in December of 2024.
December
He was arrested.
10th.
Where does it show that the crime took place on December 6th?
On the warrant,
On what warrant?
the one that I received this morning.
The one that says contrary to condition number 21 on order of probation dated 12/6/2024, the offender was arrested.
Okay.
So that 12/6/2024 is not referring to the date of arrest. It's referring to the date that he was placed on probation.
Okay. And Mr. Redis, when did the alleged crime take place?
July 19th of 2024.
Okay. Of
So you just said
2024.
2024. Was it last year or this year that took place?
I'm sorry, all this is confusing me. I got arrested for the alleged domestic violence against Alexia Nelson on July 19th, 2025 at McDonald's.
Thank you. Your Honor, my apologies. My apologies.
All right.
I was reading this very quickly. I apologize.
All right. Again, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Redis has had full knowledge of his rights and he's had competent counsel. I will refer the matter to the probation department for an update of the pre-sentence investigation.
Your Honor, is there any way that I could get sentenced today?
There isn't. I have to give the probation department an opportunity to update your pre-sentence investigation. And I'll set sentencing for August 29th at 8:15.
Thank you, Your Honor.
Mr. Redis, your probation officer is going to be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about what's happened and about your background.
I don't believe anything has changed since my last one, Your Honor.
Okay, well, he's got to do the interview anyway.
Okay.
All right, so we'll see you back on August 29th at 8:15. You can let the officer with you know that you're done with court for today.
Thank you.
Good morning, ma'am. Are you Brenda Nicholas?
Yes, sir.
1 second. This is file 25-22170-FH, People of State of Michigan versus Brenda Lee Nicholas. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I ask Ms. McClure to place your appearance on the record?
E.B. McClure on behalf of the people.
And Miss, you are Brenda Lee Nicholas?
Yes, sir.
Okay, Ms. Nicholas, at the last hearing we had on this, Mr. Daly, there was a stipulation to withdraw by Mr. Daly as your counsel. So currently you are not represented by counsel. You are entitled to be represented by an attorney at this hearing and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you. From the
Yeah, I
public
can't.
defense.
Yeah, I tried, but I couldn't come up with the funds.
Okay.
And Judge, just for the record too, I believe we're still set for jury trial in October unless the court has vacated that date.
I don't know whether I have or not. I think under the circumstances, that would be the appropriate thing to do at this point, if I haven't already. So what I'm going to do is appoint the public defender's office to represent you. And we'll set this for a pre-trial. Let's go with September 17th. At 8:15 a.m. And in the meantime, oh, I'm sorry.
No, I'm sorry, Judge, for interrupting. I just wanted to say as well, we ordered the transcript on the April 30th pretrial, and our office has not received that yet. I don't know if that's something the court's able to follow up on or not. The preliminary exam transcript, excuse me.
I'm sorry, you ordered that when?
I have a note that it was ordered on the April 30th pretrial.
Okay. I don't see anything, just in a quick flip through of the file about that, so we'll look into that.
Okay.
Okay, so September 17th at 8:15 a.m. Ms. Nicholas, please get in touch with the Lenawee County Public Defender's Office before then.
Okay.
Okay, so you are all set for today. You can go ahead and log out.
Okay, thank you. I don't know how to do that.
Okay, Mr. Giroux, you can come forward and sit at the table here closer to the television. This is file 25-22330-FH versus Richard James Giroux Jr. We are here today for a hearing on an order to show cause relative to a alleged violation of bond conditions. We are proceeding today by video conference and in person. Sir, you are Richard James Giroux Jr.
Correct.
Have you received a copy of the motion affidavit in order to show cause?
Yes, I have.
That document alleges that you violated your probation by failing to get your 2 times weekly drug testing set up after you were released from jail on July 8th of 2020. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You are represented by Mr. Glazier on the underlying case. Do you want him to represent you with respect to this as well?
Yes.
All right. Mr. Glazier, do you know how Mr. Giroux wants to proceed with this?
Mr. Giroux, you didn't set up your testing?
I've never told you. When I got released, they didn't say nothing about, gotta go to, no testing, nothing.
Could we maybe adjourn this and have him go get set up for testing? I don't know where he does that at, but.
Right, you were supposed to contact, I'm sorry, you were supposed to contact Mr. Coast when he was released from jail. You were supposed to come over to the courthouse and talk to Mr. Coast to get that done.
And Judge, what I could do is I can meet him out in the hallway once we're done this morning. I could set him up for those 2 times a week drug testing.
Okay, so yeah, I think that's what I'd like to do. I think, do we have a pretrial set already? We do, for September 3rd. So your next date, Mr. Giroux, is going to be September 3rd. I want you to meet go wait in the hallway. Mr. Coast is going to come out to the hallway right now and get you set up with your drug testing.
Thank you.
Are you just dismissing this contempt, Judge?
I'll just set that over to the same September 3rd date for now.
Okay, adjourn to September 3rd. Okay.
Okay, Ms. Underwood, are you going to need to speak to Mr. Bowen?
I do not.
Can you hear me, Rhonda?
I can.
All right, yes, we can hear you, Mr.
Bowen.
Bowen. This is file 25-22285-FH. Wrong. It's file 24-2219-21987. People versus Daniel Don Bowen. We are here today for a pretrial conference in that case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Rhonda Underwood for Mr. Bowen.
And Ms. Underwood, where do we stand with Mr. Bowen's case today?
I've discussed this matter both with Ms. Brenner and Mr. Bowen. Mr. Bowen is establishing a very good payment history, Your Honor. He's paying. Ms. Brenner and I would ask for a 60 to 90 day adjournment in this matter, Your Honor. And I would be happy to do the stip to adjourn with Ms. Brenner's permission.
Okay, Ms. Brenner, is that agreeable?
Yes, Your Honor. This case is getting a little old, so I'm okay with giving him additional time because he is making headway, but I just wanted to bring it to the court's attention in case it's an issue on your end. We've been doing this since almost a year now. We've been giving him time, and he is making headway. His arrear just started out at over 57,000, and we're down to just over 49,000. But I did want to bring it to the court's attention in case that's an issue. But I'm okay with giving him more time if the court is.
Okay, as long as there's progress being made and we're receiving payments, I'm okay with continuing to extend those dates. So,
okay, thank you, Judge.
Let's go with October 29th at 8:15 a.m.
Thank you, Your Honor, and I will do that stip in order with Ms. Brenner's permission.
Yes, thank you.
All right, Mr. Bowen, you're all set for today. Then your next date is October 29th at 8:15.
Great. Thank you, Your Honor.
All right, Mr. Bowen, you're all set for today. Then your next date is October 29th at 8:15. Great. Thank you, Your Honor.
7+3.
Your Honor, can I have a brief breakout room with Mr. Winter, please?
Yes, give me 1 second.
Thank you, Judge.
Okay, Mr. Fleming, are you ready to proceed with Mr. Yeiter?
Yes, Judge.
This is file 25-52662-PH Trevor Hess versus Richard Yeiter. We are here today for hearing on 3 motions and orders to show cause regarding alleged violations of the personal protection order. We are proceeding today in person. I believe also by video conference. Mr. Fry, are you present?
Yes, Your Honor.
Okay, Mr. Fry, I don't see your client logged in. I don't know if you are aware whether he was going to do that or not.
I don't think he was planning on being here today.
Okay, go ahead and place your appearance on the record.
Good morning, Your Honor. Chris on behalf of Mr. Yeiter.
Brian Fry on behalf of the petitioner, Trevor Hess.
All right, and sir, you are Richard Yeiter, correct?
Yes.
Mr. Yeiter, have you received copies of the 3 motions to show cause for violating the personal protection order?
Yes, I have.
Those allege that you violated personal protection order on May 20, 2025. By recording or taking pictures of Mr. Hess on May 29, 2025. By yelling at Mr. Hess, and on July 5, 2025, by honking your horn at Mr. Hess. The maximum possible penalty for violating personal protection was up to 93 days in jail and or $500 fine. Mr. Fleming obviously already represents you in this case. Mr. Fleming, do you know how we'd like to proceed?
Yes, Judge, we would plead not guilty, ask for a hearing on these matters.
All right. Enter not guilty pleas on each of the alleged violations, and we'll set it for a hearing. Ms. Clark, can we have a half-day evidentiary hearing date for these violations, please?
Judge, we're set for a hearing on the motion to terminate on September 2nd. I don't know if Your Honor wishes to include this with those. I would have no objection to that.
That would be agreeable with me as well, Your Honor, if the court deems that appropriate.
Okay, we'll set it then for that same date of September 2nd at 8:15. I'm sorry, not at 8:15.
1:30.
At 1:30. Thank you. And the court will issue a scheduling order and send that out to you.
Thank you.
Thank you, Judge. You have a good day.
Thank you. Okay, the gentleman just joined the meeting. Turn your camera on. Can you tell me your name?
Anthony Brown, Your Honor.
Okay, Ms. Underwood, you need to speak to Mr. Brown.
I do not.
Okay. This is file 25-22285-FH, People versus Anthony Dwayne Brown. We are here today for a pretrial conference in that case, and we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Brown this morning, Your Honor.
All right, and where do we stand with Mr. Brown's case today?
Again, I'm happy to report Mr. Brown is making good progress and making regular payments, Your Honor. I've spoken with Mr. Brenner and Mr. Brown, and again, we would ask that this matter be put out 60 to 90 days. That October 29th date looks pretty good for this case as well, and I will do the stipend to adjourn with Ms. Brenner's permission.
Okay, Ms. Brenner, is that agreeable with the people?
Yes, Your Honor, that's correct, and I do agree to that.
Okay, so let's go then with that same October 29th date for the next retrial.
Thank you, Your Honor.
Thank you, Your Honor.
So, Mr. Brown, you're all set. You can log out. Your next date is October 29th at 8:15.
All right, thank you, Your Honor. Y'all have a good day.
Thank you.
Mr. Brown.
Page.
Amber Page and also Bailey Nymer. Yes, thank you. Bye.
All right, I have someone that was just brought into the meeting on a Samsung device. I need you to unmute your device and tell me your name, please. Ms. Swain, what case are you here for?
I'm here for Marshall Sosby.
Okay. This is file 09-14191-FC, People of the State of Michigan versus Marshall Scott Sosby. We are here today for a status conference on this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Bruggeman.
Jennifer Bruggeman on behalf of the people.
Allison Swain on behalf of Mr. Sosby. I am appearing via Zoom, and Mr. Sosby is also here via Zoom.
Okay, and sir, you're Marshall Scott Sosby, correct?
Yes, Your Honor.
Okay, so Ms. Swain, where do we stand? I know you're new to the case, but where are we from your standpoint?
Sure. Thank you, Your Honor. I was assigned this case in June, and so I want to apologize for not being aware of the initial status conference. But I, right now, am just sort of catching up. I have been able to get former counsel's files, so I have those. I believe I have the transcripts from this court previously. And so I think my request would be a status conference in 3 months from now, so I can give this court a realistic picture of what I think the timeline to set a resentencing date would be. I have a mitigation specialist assigned to the case, and we are collecting records and sort of moving through what we have. And there's a set of additional records that I'd like to collect, but I'm catching up. I'm familiarizing myself with the case. I've been able to go through at least all of the pretrial or at the pre-sentencing status conferences after this court took the case and it came back from the Court of Appeals.
Okay, Ms. Brugman, is there anything we need to address from the people's side today?
I don't believe so, Your Honor. I don't have an issue, obviously, with adjourning to another status conference. It is quite a lot to go through, and also an unusual case as far as what Mr. Sosby was sentenced to. So in any event, I don't have a problem adjourning it to a status conference in 3 months. Whatever works for the court is fine with me.
Okay, so let's go then with a status conference on November 12th at 8:15 a.m. And Ms. Swain, would you be willing to do a stipulation in order for that adjournment?
Absolutely.
Okay, is there anything else that we need to address today?
No, Your Honor, just put on the record that we will do the writ. And again, all via Zoom, I assume.
Yeah, Zoom is fine with me if that's agreeable with everyone else.
That works for us.
Okay, thank you.
Okay. Thank you then, Mr. Sosby. You are all set for today.
All right, you have a good one.
Thank you.
All right, Ms. Swain.
Thank you, Your Honor.
Thank you. All right, and Miss, you are Amber Page?
Yes.
This is file 23-21372-FH People versus Amber Elaine Page. We are here today for arraignment on a warrant for probation violation. Miss, you are Amber Elaine Page, correct?
Correct.
Ms. Page, have you received a copy of the warrant?
Yes, sir.
Okay, that warrant alleges that you violated probation by failing to attend treatment as instructed by your probation officer in July 2025, by being positive and admitting to using methamphetamine on August 10th, 2025, and by violating state law in that you used methamphetamine again on August 10th, 2025. You had previously been convicted in this case of failing to pay child support, and the maximum possible penalty for that offense is up to 4 years in prison. Do you understand that?
Yes.
You are entitled to be represented by an attorney here today and at any other proceedings we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the Public Defender's Office. Do you understand that?
Yes, I understand.
Do you want to be represented by an attorney today?
Yes, sir.
Do you have the ability to pay for your own attorney?
No, sir.
I will put you in a breakout session with Ms. Underwood if you give me just a moment.
All right.
And Mr. Hagglethorne, are you ready to proceed with Mr. Nymer?
I am ready, Your Honor.
Okay.
Mr. Olsaver, I got kicked out of the break room.
I'm sorry?
I got kicked out of the break room.
Okay, give me 1 second. Let me set that up once more.
Your Honor, I went to the,
Yeah, there was a little issue. I'm setting that up again.
thank you.
Okay. All right, this is file 24-21792-FH, 24-21872-FH, 24-21873-FH, and 25-22327-FH. People versus Bailey Assad Nymer. We are here today for pretrial conferences in all of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Allison Arnold for the people.
Jason Hagglethorne on behalf of Bailey Nymer.
Okay, there are also pending contempts in the 24 cases. So, Mr. Hagglethorne, where do we stand with Mr. Nymer's cases today?
We're getting closer to wrapping them up. I know I've spoke with Ms. Arnold as well as Mr. Sneed. I have some stuff that I'm going to be going over with Mr. Nymer today, and I'm hoping we can get that wrapped up. What I would request is, I know he's got a couple things pending in the district court in front of Judge Morgan as well. So one of the issues, not the issue, but as it stands, the plea has an effective date up to September 18th. So I'm just asking the court to adjourn that matter to that date to finalize some of those matters and go over the full deal with Mr. Nymer today.
Judge, it's September 15th, just to make it clear.
Okay, that makes it a little difficult on my calendar. Could we do September 17th?
Yes.
Yes, I can do that.
Okay. So September 17th at 8:15 a.m. And Mr. Hagglethorne, could you do stipulation and orders for adjournment in each of those files?
Yes, Your Honor, I can do that.
And if you're able to talk to Mr. Nymer and get it resolved before then, you're welcome to contact the court. And if we have some available time, we can get in before then.
Okay, thank you, Your Honor. And Judges, Allison, is it all right if I pop up to talk to you real quick before I go over to see Mr. Nymer?
Sure.
Okay, I think we're all set for today then. Thank you.
Thank you, Your Honor.
Okay, Mr. Winter, I don't believe I have Mr. Pinkelman no, I'm sorry, who was Mr. Lake logged in? I don't know if you've had any communication with him at all.
Your Honor, I just had, I just exchanged text messages with Mr. Amadeo. As the court will see from the record, Mr. Amadeo was just appointed for this. There was apparently a problem with prior counsel from the defendant's office with a conflict, but Mr. Amadeo has made clear that Mr. Lake was aware of this and was made aware of this court date. Ms. Brenner and I were just saying that we can't find him in the Zoom. And so whatever the court does is whatever's necessary, Your Honor.
Yeah, I'd be requesting a bench warrant, Your Honor. And I don't know if you want to officially call it.
Let me. Second. Sergio, do you want to check the hall for Richard Lake? This is file 25-22255-FH, People of the State of Michigan versus Richard Lewis Lake Jr. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Peter Winters, substituting for Mr. William Amadeo this morning for the defendant.
All right, and we did have a discussion off the record. This matter was set for hearing this morning at 8:15. It is now 9:06 a.m. Mr. Lake is not present here in the courtroom, and he is not logged into the session. It's now 9:06. It was set for 8:15. Mr. Winters, is there anything you would like to say with respect to Mr. Lake at this time?
No, Your Honor. I know that he has other cases pending in another court, but Mr. Amadeo has informed me that Mr. Lake was made aware of this hearing, and so I have no idea why he is not present, Your Honor.
Okay.
Your Honor, this hearing was set at our last hearing back in June. The defendant had asserted that he was working. He could now start paying $200 a week. So we adjourned to this date to give him that opportunity. He's paid absolutely nothing since that time. I'd be requesting a bench warrant with a cash only bond.
Okay, I do have one person I haven't identified yet that is in the session that just turned your video on. The gentleman sitting in your car and looks like a white t-shirt. I've just sent you a request to unmute your video. I'm sorry, unmute your audio. I need you to unmute. Can you tell me your name?
Sure.
Okay, thank you, sir. I'll be with you in just a minute. All right, so I can now confirm that everyone in the Zoom session has been identified and Mr. Lake is not here. So I am going to issue a bench warrant. I believe this is the first failure to appear for Mr. Lake, so he would be entitled to the 48-hour waiting period that will allow him that. However, if we do not hear from him within that time, I will issue a bench warrant. Ms. Brenner, do you know the current arrearage amount?
Yes, Your Honor, it's $22,748.02.
I will set bond on the bench warrant in the amount of $22,748.02 cash.
And Your Honor, you want me to prepare the bench warrant or does your office? I forget.
For the failure to appear, we will prepare that.
Okay, thank you, Judge.
Okay, so I think we're all set on that one. Thank you.
Thank you, Your Honor.
Okay, we were back on the record in file 23-21372-FH, People versus Amber Elaine Page. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Ms. Page. Your Honor.
And do you know how Ms. Page would like to proceed today?
Yes, Your Honor. I'm just a little, I would ask the court to enter a not guilty plea at this point. I'm just a little concerned with the way the violation is written, that it's practically an invitation for Ms. Page to be charged. So I just want maybe a week, Your Honor, to ascertain that that's not going to be done. Ms. Page, I believe this is a child support case, so Ms. Brenner may want to weigh in. Ms. Page is recently employed. She does have a new job. She has, I believe, just started making a couple payments that she's been missing. So I've spoken to Ms. Walsh, and I don't believe she would have any objection to Ms. Page being released on a bond with appropriate reporting conditions for her to work, and we can set this out a week or two and just make sure that nothing's going to result from this.
Okay, so I can set this for September 3rd at 8:15. Ms. Walsh, was that the correct representation of your position on the issue of bond?
Yes, Judge.
How often is she currently testing under her probation conditions?
She's supposed to be testing random, but she has failed to do so. So we need to make sure that she's going to follow through with doing that as well. I don't know what else to do at this point.
All right, so what I'll do at this point is issue a PR bond with a requirement for random drug testing. Ms. Page, you need to understand that a missed test is a violation of that bond condition, and I will issue another warrant if there's any missed test.
Okay. Thank you, Your Honor.
Ms. Walsh, do you want her to report when she's released?
No, she can just give me a call.
Okay.
Okay, thank you.
Ms. Page, I need you, don't leave yet. Your additional bond conditions that you report to Darren Coast and Lenawee Pretrial Services as often as he may require as well. That you not use any alcohol, marijuana, or illegal controlled substances, that you participate in the substance abuse testing or monitoring program or testing, as I've already stated. What hours do you work, Ms. Page?
I usually work between about 1 to 2 o'clock till about 10 o'clock at night.
That's going to change though, Judge. She's required to not be in Jackson County anymore by me. That's where she gets into trouble at. So she's going to have to find employment closer to Lenawee County.
Yeah, which I can start looking today.
All right, so I'm gonna have a curfew of 11 p.m. to 6 a.m. So when you're released, Ms. Page, you'll need to come over to the courthouse and see Mr. Coast.
Okay.
Okay, and
That's
I'm
on the-
located up on the 3rd floor, so once you come out of the elevators, go across the hall into the clerk's office, let them know that you would like to see me, and I'll meet you out in the hallway then.
Okay.
Okay, now you're all set then, Ms. Page, you can let the officer with you know that you're done with work.
All right. Thank you.
Okay, Mr. Glazier, I have the plea agreement now for Mr. Stump.
All right.
It hasn't been signed by you or Mr. Stump.
No, we didn't. It's just, but we're agreeing to it, Sharon.
You can sign it, Your Honor.
Yeah, you can
All right,
sign.
I'm not gonna sign documents for people.
Yeah, I'm done.
Ms. McClure, do you want to go forward without the signed agreement, or what are we gonna do?
Because it's Mr. Sneed's case, I don't want to agree to that, but if Mr. Glazier wants me to sign on his behalf, I can
Yeah,
come
she-
up after court and sign.
She can sign on behalf of me and my client both, Your Honor.
So as long as they agree to the plea agreement, I can come up and sign on their behalf.
That's fine.
Okay. Mr. Stump, have they given you a copy of the advice of rights form?
Yes, Your Honor, I've signed it.
Okay. Yeah, okay, this is file 25-2369-FH, Michigan versus Cody Dwayne Stump. We are here today for an arraignment in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, on behalf of the people filling in for prosecutor of record Isaac Sneed.
John Glazier on behalf of Mr. Stump.
And Mr. Glazier, does Mr. Stump wish to have the information read this morning?
No, Your Honor, we'd waive that. He's gonna plead guilty to count 2 with a killabrew to no prison time, meaning that it would be up to the court to sentence him to whatever jail time up to 1 year. Counts 1 and 3 would be dismissed. He's pleading to the cost of the 4-year count 2.
Okay, yeah. Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, with the addition of, just to make sure Mr. Stump knows that this is a tier 2 SORA offense, and it's a tier 3 if he has a prior conviction for a tier 2 offense. In addition, the prosecutor is recommending a sentence of 12 months jail, but there is an agreement to no MDOC.
Okay, do you understand all that, Mr. Stump?
Yes, Your Honor.
And you want to continue with the plea?
Yes, as long as I can get jail time.
Okay. Would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Cody Dwayne Stump?
Yes.
Mr. Stump, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, accosting a child for immoral purposes?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $4,000 fine?
Yes.
Do you also understand that depending upon your criminal history, this would either be a tier 2 offense under the Sex Offender Registration Act, which would require 25-year registration under SORA, or it's a tier 3 offense, which would require lifetime registration under SORA?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been addressed on the record here today. Is that correct, Ms. McClure?
That is correct.
That's correct, Your Honor.
So your understanding, Mr. Stump?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Stump, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about March 18th, 2025, in the village of Clayton, Lenawee County, Michigan, that you did commit the offense of accosting a child for immoral purposes?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises not disclosed to the court on the record today, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Stump to plead guilty today?
None, Your Honor.
No, Your Honor.
No.
Mr. Stump, other than as we've talked about it on the record today, has your attorney promised you any particular sentence or estimated what that sentence would be?
No more than a year, Your Honor.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazier, do you want to establish a factual basis?
Yeah, Mr. Stump, on or about March 18th of this year, you were in contact with a minor child, is that correct?
Yes.
Was that by a cell phone or computer, or how were you in contact with her?
It was by my phone.
Okay, and this girl, how old was she, do you know?
I did not know. I wasn't even thinking right at the time. I was on methamphetamines.
Would you agree that she was a 12-year-old girl?
Yeah, okay, I didn't know.
Yes, Your Honor.
All right, and during that conversation or texting, you sent her a picture of your penis and asked her to send you a picture of her breasts. Is that correct?
Yes.
And that all occurred here in Lenawee County in the state of Michigan. Is that true?
Yes, it did.
All right, I don't have any other questions, Your Honor.
I'm satisfied with that factual basis. Thank you.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
Yes, Your Honor.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Stump has had full knowledge of his rights. He has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been stated on record here today, which I will take under advisement pending pre-sentence investigation. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 25th at 8:15 a.m. Mr. Stump, someone from the probation office will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
All right, you can let the officer with you know that you're done with for today.
Can I speak to
Thank
Glacier?
Yeah, I'll
Thank
put
you.
you in a breakout. Mr.
Okay,
Glazer wants to
thank
speak to you.
That's all I have with you.
Mr. Glazer, he wants to speak with you in a breakout session.
Oh, he does? Okay. All
Yeah.
right. I didn't hear that.
Okay, let's see, Mr. Casper, I've got Mr. Snyder here. Ms. Underwood, Mr. Cherry is here. Do you need to speak to him?
Just for a second, Your Honor.
Okay, Mr. Chair, I'm going to put you in breakout session with Ms. Underwood, if you give me just a moment. Mr. Casper and Mr. Snyder seems to be stuck between the breakout room, or I'm sorry, between the waiting room and main session, and now he has disappeared. As soon as we have Mr. Snyder back and can find him, we'll get to you. Mr. Goldstein, are you ready to proceed with Mr. Simmons?
Yes, Your Honor.
Okay, this is file 25-22121-FH, People versus Isaiah D'Angelo Simmons. We are here today for a final pretrial. In this case, we are proceeding today video conference. First going to have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonet for the people.
David I. Goldstein appearing on behalf of the defendant.
And so this is a final pretrial. We do have a trial date scheduled for August 26, 27, 28. Are we ready to proceed with trial at this time?
Your Honor, there is a situation. I'm sorry, Alex, go ahead.
Sorry, Mr. Goldstein. I was just saying the people are ready to proceed, Your Honor.
Your Honor, I'm going to be asking for a 1-week adjournment of the final pretrial. There's a situation developing that might prevent me from being available on that date. I'll know better in the next day or two. And I also want to talk to Mr. Bayonetto about the matter. I'm assuming you're trying it, Alex?
It will be me and Mr. Sears, yep.
I'm sorry, you broke up there for a second.
It will be me and Mr. Sears trying it.
Okay. All right, so I'm asking for a 1-week adjournment, Your Honor.
All right, so we can do a pretrial on August 20th and at 8:15.
Thank you, Your Honor. Mr. Bayonet, I'll be in touch.
Okay, thank you.
Mr. Goldstein, would you do that stipulation in order for the adjournment, please?
I will do it, Your Honor. Thank you.
Okay, thank you. Okay, we have Mr. Snyder now. Mr. Simmons, you're all set. You can log out.
Thank you.
This is file 25-22313-FH. People versus Justin Michael Snyder. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
For Counsel on behalf of the defendant.
Okay, and Mr. Castleberry, where do we stand with Mr. Snyder's case today?
Your Honor, we received a plea offer on Friday, and I've spoken with the prosecutor. I need an adjournment of this pretrial so I can discuss it with my client. I do believe we are close to resolution.
Okay. Let's go with September 17th then at 8:15, if that works.
That's good with me, Your Honor.
Okay, and Mr. Castleberry, would you do a stipulation in order for that adjournment, please?
Hello, Your Honor.
All right. So, Mr. Snyder, your next date is September 17th at 8:15 a.m. You can log in using all the same Zoom information you used today. So you can go ahead and log out then, Mr. Snyder.
Thank you, Your Honor.
Thank you, Mr. Castleberry. Mr. Valero, I don't have Ms. Rembert here. Have you had any communication with her?
Your Honor, I have our email that they were going to nollie the case. I did try to call her. I don't know if the nollie's been filed. The number I have does not work or something.
I don't have anything.
Mr. Sneed does have a note in the file indicating he would file the nollie before today's date. So maybe it was filed yesterday and just hasn't made its way yet.
That's possible.
So could we adjourn a judge a couple weeks and we'll get a hold of her, wait for that nollie. If the court wants to do that.
Yeah, let's set it then for the 17th, September 17th at 8:15, and hopefully we'll have that taken care of in the meantime.
Thank you, Judge. I'll do a stip in order.
I was gonna say, in lieu of a pretrial, another pretrial, I do see the nollie in the file. I could email it if you all want me to.
That's fine.
Okay.
I'll just get it signed today and cancel that pretrial then.
Okay.
All right then. Do you call for Alan Whitman? Yes. guess just Alan. Mr. Murphy, do you need to speak to Lucas Rutledge?
Yes, if I could, Your Honor, please.
Okay, and Ms. Underwood, are you ready to proceed with Mr. Cherry?
Yes, Your Honor. Thank you.
This is file 22-20683-FH, People versus Paul Edward Cherry. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. First, can you have the attorneys place their appearance on the record?
Rhonda Underwood for Mr. Cherry, Your Honor, and this is a violation of probation, I believe.
Yeah, I apologize. I'm not sure what I said, but it's a violation of probation.
And I apologize for my camera. For some reason, it's backwards. Your Honor, Mr. Cherry has filed Chapter 13, and we anticipated that the information on that case would have made itself to myself and the court. Apparently, it has not. I checked with court staff a couple days ago. I had Mr. Cherry light a fire under his bankruptcy attorneys, Mars and Terry. So it's my understanding we should receive that information. And so I would like just a couple weeks adjournment on this matter, Your Honor.
Okay, I will adjourn it to September 17th at 8:15.
Thank you, Your Honor.
Thank you. So, Mr. Cherry, your next date is September 17th at 8:15. You can log in using all the same Zoom info that you used today.
Thank you, Your Honor.
Thank you. You can go ahead and log out then.
Your Honor, do you by any chance have Mr. Keir in your waiting room?
I do not. So I can call that one. It is file 25-22274-FH. People versus Timothy Allen Keir. We are here today for a pretrial hearing. There's also a show cause hearing scheduled for today. And we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Stevie McClure, map of the people.
Rhonda Underwood for Mr. Keir this morning, Your Honor.
The record should reflect this was set for a pretrial conference today at 8:15 a.m. It's now 9:38 a.m. Mr. Keir is not present here in the courtroom in person. He has not logged into the Zoom session at any point this morning. I have identified everyone that's been here, and Mr. Keir has not logged in. Ms. Underwood, is there anything you want to say on behalf of Mr. Keir?
I have no knowledge as to his whereabouts, Your Honor. And I have tried to call.
And Judge, I did arrange to have 2 times a week drug testing with him at the courthouse at half cost. He has neglected to come in. I've yet to do a single drug test on him.
Okay, don't see other failures to appear.
Judge, he did have one in district court in February. Or yes, February. In all of
So
his files.
there is a prior failure to appear then, and in addition to that, he has apparently not been drug testing at this point, so I am going to issue a warrant directly for Mr. Kier. I will set bond on the bench warrant in the amount of $50,000 cash or surety.
Thank you, Your Honor.
Thank you. Mr. Murphy, are you ready to proceed with Mr. Rutledge?
Yes, Your Honor.
This is file 25-22275-FH, People versus Lucas Allen Rutledge. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First hand, the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Rutledge.
And I'm sorry, can we lose Mr. Rutledge? I think we've lost Mr. Rutledge. Popped up for a moment when he came back from the Zoom session and now he's gone. So I guess we'll wait a minute to see if he gets logged back in.
I'll try to contact him, Your Honor. Thank you.
Thank you. In the meantime, oh, there he is. He just logged back in. Okay, we do have Mr. Rutledge back with us now. Mr. Rutledge, can you hear me?
Yes, sir.
Okay, so Mr. Murphy, where do we stand with Mr. Rutledge's case today?
Your Honor, I was going to ask if the court would set a one-day jury trial on this matter. I've had Mr. Rutledge in my office. We reviewed the video footage, the video evidence in this matter, and he does not wish to enter a plea of guilty at this time. So I think setting a jury trial is the next step. So I would ask the court to go ahead and do that if we could, please.
Ms. McClure, do you agree one day is sufficient?
And I hate to do this to the court, but Mr. Sneed did indicate that if one of his cases was to be set for jury trial, I think this one in particular, he wanted to log in for it. So could I have him do that?
Sure.
Okay, thanks.
Mr. Murphy, while we're waiting, do you need to speak to Mr. Dillenbeck?
I think we're ready to proceed on the record on that, Your Honor. I spoke with him yesterday.
This is file 25-22297-FH, People of the State of Michigan versus Ryan James Dillenbeck. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, they have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Dillenbeck.
And where do we stand with Mr. Dillenbeck's case today, Mr. Murphy?
Your Honor, I was going to ask if we could adjourn for another pretrial. I was trying to find in my file and in the emails a plea offer, and I wasn't able to find one. And I was just going to ask again if we could just adjourn so I could talk with Ms. McClure about, clarifying that before the next one and hopefully have the case resolved by then.
And as it relates to a plea in this case, I know he had a number of cases pending, and I think this one was kind of a straggler. So it wasn't included in that original plea offer. So I don't think I've made an offer in this case. So I would agree, Mr. Murphy and I just need to chat a little bit.
Okay, let's go with September 24th at 8:15 a.m.
Thank you, Your Honor. My office will do a stipulation in order to adjourn to September 24th at 8:15 a.m.
Thank you.
And Matt, if you just want to email me on this, what you're thinking, and we can chat.
Yeah, I'm sorry. I meant to do that Monday and I forgot. So
That's okay. Thank you.
Okay, so Mr. Dillonbeck, you're all set for today.
All right. Thank you. Y'all have a great day.
thanks, Mr. Dillonbeck. I'll call you again soon, okay?
All right. Thank you. Bye.
And Judge, as it relates to Mr. Rutledge, Mr. Sneed doesn't want to log in, but he just wanted me to let me know what his availability was for trial. So I have that now, so we can proceed.
Okay. So do you think one day is sufficient then?
I believe so, yes.
All right. So Ms. Clark, can we have a one-day jury trial date for Mr. Rutledge?
And Mr. Sneed's requesting something after October, if the court is able to accommodate.
Thursday, November 13th at 9 a.m.
That won't work for me, Your Honor. The first 2 weeks of November scheduled for a jury trial and Judge Anzalone. Maybe the end of November or further on.
Tuesday, November 25th at 9 a.m.
That would work for myself. Thank you.
It appears to work for the people. Yeah, I believe that should work for the people.
I'm sorry, what was that date?
November 25th.
Okay. So November 25th at 9 a.m. Let's do a final pretrial on November 19th. Court will issue a scheduling order for that. Is there anything else that we need to address today?
Nothing from the defense, Your Honor. Thank you.
Nothing from the people.
Okay, Mr. Rutledge, you can go ahead and log out then.
Mr. Rutledge, I'll contact you to schedule an appointment, okay? Have a good day.
Okay.
Have a good day.
Mr. Wayne. I think we called for him.
It did call. Is he in the front office?
No, I don't think he's never, I've never seen him.
All right, Kelly, you get into just yours. And Nancy Coley and Brandon Clark, please. Thank you. Great, bye.
Are you Mr. Smith?
Yes, sir.
Okay, do you want to come forward?
Yeah.
Sure. Doesn't. I apologize. Somehow I missed that you were here personally.
That's fine.
This is file 25-22207-FH, People versus Michael David Smith. We are here today for arraignment on a summons for probation violation. And we are proceeding today in person. Sir, you are Michael David Smith. Matthew, I apologize. Is that why you're raising your hand?
Yeah.
Sorry, looking right at it and I said the wrong thing. Matthew David Smith. Mr. Smith, have you received a copy of the request and summons for probation violation?
Yes, sir.
That document alleges that you violated your probation by consuming alcohol and testing positive for that on July 15, 2025. You had previously pled guilty in this case to breaking and entering a building, attempted breaking and entering a building with intent. The maximum possible penalty for that offense is up to 5 years in prison. Do you understand all of that?
Yes, sir.
You are entitled to be represented by an attorney here today and at any other proceedings that we have regarding this matter. If you can't afford your own attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney?
Truthfully, I think I should be able to just do this by myself on this one.
Okay.
I mean, well, if that's okay. I mean,
It's completely your choice. You're entitled to one if you want one. If you
yeah,
want
I feel like we can just resolve it.
okay. If at any point you change your mind, you can tell me that.
Okay.
Okay. Do you understand that you have a right to contest the violation of probation and to have a trial on it?
I understand.
Do you understand that throughout any trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have the court order any witnesses that you have for your defense to appear at your trial. You or your lawyer could ask those witnesses questions. Do you understand that?
Yes, sir.
You'd also have the right to have any witnesses against you appear at your trial. Do you understand that as well?
Yes, sir.
And you or your lawyer, if you had one, would have an opportunity to ask them questions. Do you understand that?
Yes, sir.
You're not required to testify, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you would have the right to testify if you wanted to testify. Do you understand that?
Yes, sir.
Do you know how you want to plead to the charge that you violated your probation?
I just want to plead guilty to it.
Okay. Do you understand that by pleading guilty, you're giving up your right to a trial and right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
So you were placed on probation in this case. It's like sentencing was June 9th, so that's when you were placed on probation. Is that correct?
Yes, sir.
And one of the conditions of your probation was that you not consume any alcoholic beverages. Is that also correct?
Yes, sir.
And let's see, on July 15, 2025, did you test positive for alcohol?
Yes, sir.
And did you consume some alcohol that caused you to do that?
Yes, it's I consumed kombucha. I didn't know that it was a non-alcoholic beverage. I didn't realize that there was a trace of alcohol in it and stuff. And I had them when I was at work. So I worked third shift. And like I'm in the drug court, and everything, and like so we've got it all resolved and stuff over there and stuff. So it was totally accidental.
Okay. All right, I'll accept your plea then. It's been given understandably, voluntarily, and accurately. You've had full knowledge of your rights and you've had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation. And we'll set sentencing for September 19th at 8:15 a.m. Your probation officer will be in touch with you to do an update of your pre-sentence report. When you do that interview, please be truthful about the offense and about your background.
Yes, sir.
Ms. Holly, do you need to have him do anything other than just his next report?
Yeah, he's reporting to Hillsdale, so he can just keep reporting it there.
Right.
Thank
So
you.
Just keep reporting to Hillsdale as you've done. Okay, so you're all set for today.
Thank you.
If you want to attend the sentencing by Zoom, you're welcome to do that.
Okay, sweet.
And Bailiff has our Zoom.
Thank you. Yes, I worked third shift, I got out at 7 o'clock in the morning. Well, actually, that's another day at 6 o'clock, so I got to take a shower, so.
Okay.
But we still got here. Thank you.
All right, the gentleman at the jail, you're Mr. Whiteman.
Yes, sir.
Mr. Malero, do you need to speak to Mr. Whiteman?
Yeah, I could talk to him real quick.
Okay, and Mr. Murphy, do you need to speak to Ms. Cole?
If I could, please, Your Honor.
Okay, 1 second.
Thank you, Judge.
You asked for. This is file 18-46035-DS. Natalie Keene versus Brandon Clark. We are here today for a arraignment on a bench warrant in this case. Sir, you are Brandon Dean Clark?
Yes, sir.
Mr. Clark, have you seen a copy of the warrant? All right, we'll send a copy of the warrant over to the jail and have them bring you a copy. While that's happening, Mr. Clark, I will let you know that the warrant alleges that you failed to appear for a show cause hearing on July 10th, 2023. In addition to that, you have a child support monthly charge of $591, and there is currently an arrearage in the amount of $6,173. Did you understand, Mr. Clark, that if you were to plead guilty to either of those offenses, that the court could sentence you to jail for up to 30 days?
Your Honor, just for clarification, the current balance is 18,796.
Oh, I apologize. 18,000. I was reading the wrong one. Thank you. $18,796.14. All right, so again, Mr. Clark, do you understand it's a crime to fail to pay child support to the best of your ability up to the amount ordered?
What's that?
Do you understand that it's a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes, I do.
Do you also understand that it's a crime to fail to appear in court when you've been ordered to appear?
Yes.
If you were to plead guilty or be found guilty of either of those offenses, the court could sentence you to jail for up to 30 days. Do you understand that?
Yes, I do.
You are entitled to a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes, I do.
You are entitled to have an attorney represent you today and at any other hearings that we have regarding this matter. Do you understand that?
Yes, I do.
If you want an attorney and you don't have the money to pay for one, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes, I do.
Do you want to be represented by an attorney?
Yes, please.
Do you have the ability to pay for your own attorney?
No.
Okay, I will appoint the public defender's office to represent you. Our public defender that handles these is not with us right now, so let the officer know that you're done with court for now. As soon as I have her logged back in, we'll call for you again.
Okay.
Someone took Okay, Mr. Murphy, are you ready to proceed with Ms. Coley?
Yes, Your Honor.
This is file 25-22120-FH. People versus Cassie Lynn Coley. We are here today for a pretrial conference in this case. There are also pending contempts of court. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
PB McCormick, the people.
Matthew Murphy, appearing on behalf of Ms. Coley.
And Mr. Murphy, where do we stand with Ms. Coley's case today?
Your Honor, my understanding from the offer from the people will be for Ms. Coley to plead to an attempted retail fraud first degree and to an R&O. No further agreement about sentencing or bond change or anything to that effect. At this time, again, that's what I have in my notes, but I couldn't find a paper or the plea agreement actually sent over. Ms. Coley would want to plead guilty to that today. She doesn't want to delay anything anymore. She wants to take responsibility. I didn't know if Ms. McClure, if I was correct on that, if a plea agreement could be sent over or not.
It appears to be an accurate plea. In addition to pleading to, it looks like 2 retail frauds.
Yeah, she's already pled to the
Okay.
the misdemeanor files. It's the only one remaining is the felony file up here.
Okay. And I believe there will be additional charges for the tether. I don't know if that changes anything for you, Mr. Murphy.
Oh, I guess I was trying to get, because I hadn't had any answer about that, if there was going to be new charges or not for that, because it hasn't been charged yet.
It looks like Isaac put a note in yesterday that he was going to do that.
Well, I guess, I mean, she wants to take responsibility for these retail frauds. If there's a plausible pending charge, I guess we'll deal with that as it comes along. But if we could enter the plea on this today, is what I'd be asking, I guess. Well, do you have a time frame of how long it would take for that charge to be authorized and go through to get it arraigned?
I do not, but I am okay preparing the plea and amended for this plea.
Yeah, Your Honor, I don't want to delay for that other file to come up if it's going to. I'd rather just continue with this today, clear up this file, and then again, if they're going to charge for the tether issue, then and continue with that, then we'll address that in the appropriate time.
Okay, so Ms. McClure, can you have that amended information prepared? And we will have someone at the jail bring Ms. Coley an advice of rights form.
Your Honor.
So we'll pass this for a minute till we get that stuff taken care of.
Oh, Kelly, can I
Thank you.
Could someone take Cassie Coleman and advice of rights form? Thank you. Thank you. Bye.
Okay, Ms. Rember, can you hear me?
Yes.
Thank you for logging in. It's my understanding that your case is going to be dismissed and that the paperwork for that is on its way to me. So you're all set today.
Okay, thank you. I'm so sorry.
That's no problem. You're all set and there won't be
Thank
any more
you.
dates on this. Yep, thank you. Okay, Mr. Valera, are you ready to proceed with Mr. Whiteman?
Yes, I am, Your Honor.
This is file 24-22035-FH. People versus Alan Gene Whiteman. We're here today for a pretrial hearing in this case. We're also here on 2 contempt of court for alleged violation of bond conditions. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B. McClure, on behalf of the people.
Salvatore Malero on behalf of Mr. Whiteman, Your Honor.
And where do we stand with Mr. Whiteman's case today, Mr. Malero?
Your Honor, Mr. Whiteman has a pending felony down in district court. It's a 2-year R&O, so it's not a high severity case. That's scheduled for the 18th for a probable cause. So I'd like to adjourn this case out to see what happens with that. I'd also like to address bond debtor.
I'm sorry, you said August 18th, was that pretrial?
Yes.
Okay. So I'll set this then for the August 27th. I think that if it were bound over, that's the day it would be here for arraignment. And what is it you'd like to address about bond?
So, Your Honor, Mr. Whiteman has been missing AWOL for about 7 months on this case. But where he was found was at his employment. So I don't believe there's a conscious effort to abscond. I was kind of surprised that a man in his 30s would give such a short shrift to pending felony charges. But he is employed. He'd like to maintain that employment. I'd ask the court to consider imposing perhaps a $1,000 cash or surety bond on his pending matters and any contempts, and impose any drug testing requirements, so that certainly there's repercussions if Mr. Whiteman doesn't take this as serious as he needs to, financially anyways. And I, Judge, I think Mr. Whiteman would agree, I kind of chewed him out a little bit for this because he's way too old to be doing this. I did look. It doesn't appear he has much of a criminal history, if any, other than these charges that I can tell anyways. And so that could account for some of his ignorance in these matters. So that's what I would ask the court to consider.
Ms.
Your Honor, the people's only hesitation in this case is that I think it's clear from the charges and the history here, the Register of Actions history, that Mr. Whiteman does struggle with controlled substances. Just to give the court a procedural history, back in December of 2024, we had a pretrial where it was reported that this defendant was continuously testing positive for meth and also missing screens. He was undergoing treatment at CMH, so we did not issue a bench warrant at that time. But then the court did indicate that if he missed other tests, that it would issue a bench warrant. And then our next date was that January 22nd date where he did not appear and he had failed to drug test and had a bench warrant out for that. So to me, that just shows that he knew if he didn't test, he was going to have a bench warrant. So he didn't come to court when he was supposed to in January. That just logically, that's what it seems like happened. And then obviously he hasn't been back in court until now. So I don't think he can claim ignorance that he thought this was just gone or taken care of, and that's why he didn't come into court. I think he knew that these were pending. Anyway, so that is the people's hesitation on this. I'm not sure that, keeping him in jail until there's a resolution is the best solution here, but there does need to be something in place to ensure that he's complying with the court's orders and to ensure that we can get to a resolution on this.
Okay, so Mr. Whiteman in this case, he's charged with possession of methamphetamine, and he has had a slew of positive drug tests and then failed to appear in January and wasn't picked up until August 8th. And a low bond in this case just isn't going to satisfy me that based on the behavior that I've seen that he would do what he needs to do, because he had that opportunity and he chose to do otherwise. And so I think in order to ensure his appearance, I think the bond is rationally set where it needs to be. It seems pretty clear that there's a significant substance abuse problem going on here. And without addressing that in some way, I just can't think that anything would happen other than we'd be back in the same spot that we were just in. And I'm not willing to go there. I've taken that chance and it didn't work out. So I would be willing to release Mr. Whiteman to residential inpatient treatment if that is of interest to him, but I'm not willing to reduce the bond for other reasons.
All right, Judge, I'll have our client advocate reach out to him if that's interested. If he's interested in that, we'll get a hold of the court and set something up.
Okay. Thank you, then, Mr. And you can let the officer that's with you know that you're done.
Can I speak with Mr. Malero one more time, please?
Okay. Good morning, Mr. Lyons. Are you here on Mr. Fenton?
Yes, Your Honor. Good morning, and apologies for not having this on my calendar, Your Honor.
Okay, we'll call for Mr. Fenton right now.
Thank you.
And we're waiting on some stuff from his school.
Could we have Michael Fenton, please? Thank you.
We'll call Patrick Skinner cases. This is file 24-22031-FH and 24-22029-FH. This is Patrick Lee Skinner. We are here today for a hearing on a request and summons for probation violation in each of those cases. These were set for hearing today. And 8:15 a.m. It is now 10:20 a.m. Mr. Skinner has not appeared. Based on that failure to appear, the court is going to issue bench warrant in each file. I'll set bond on each bench warrant in the amount of $25,000 cash or short. Mr. Lyons, do you need to speak to Mr. Fenton?
Yes, Your Honor.
Okay. Okay, Mr. Miller, was there anything further we need to address with Mr. Whiteman's case?
Judge, I never got into the breakout with him, and I couldn't find where I could get in by myself, so.
Oh, I'm sorry, you never got there.
Yeah,
Let
I didn't
me
want to
try-
be impolite and interrupt you.
Let me try once more.
Thank you, Judge.
Did you do Anthony Brown?
Yes, he got
I thought so.
adjourned.
Okay. Thank you.
So she's-
I did just forward the amended information for Miss Foley.
Okay, thank you.
And I did not prepare a plea form. Mr. Murphy, would you like me to prepare that?
I'm sorry, what was that? I didn't,
Did you want me to prepare a plea form?
it's purely up to you guys, I think, because I thought it was something you guys required.
Well, just because it's so last minute, I guess we'll just go forward with the amended.
Yeah, I'm fine with continuing
Okay.
without having the,
But typically, yes, we would want it, but I'm okay not having it for this plea.
Okay. Ms. Coley, had someone at the jail brought you an advice of rights form?
Yes, Your Honor.
Okay. Okay, we're back on the record in file 25-22120-FH People versus Cassie Coley. We do now have an amended information. And we are ready to proceed with the plea. Ms. Coley, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Cassie Lynn Coley?
Yes, Your Honor.
Ms. Coley, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 attempted retail fraud first degree?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2.5 years in prison and or a $5,000 fine or 3 times the value of the property taken, whichever is greater?
Yes, Your Honor.
Are you satisfied with Mr. Murphy in the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Murphy?
that's correct, Your Honor.
Is that also your understanding, Ms. Coley?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Coley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
And have you had an opportunity to read that advice of rights form?
Yes, Your Honor.
And have you signed that?
No, I haven't.
Okay, in order to take the plea, I would need to have you sign that.
I haven't.
I'm sorry, I couldn't understand what you said.
I haven't. That's fine.
Okay. How do you wish to plead to the charge that on or about October 16th, 2022 in the city of Adrian, County of Illinois, state of Michigan, that you did commit the offense of attempted retail fraud first degree?
Guilty, Your Honor.
Has anybody made any threats or promises to you to get you to plead guilty?
No, Your Honor.
You understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain in order to induce Ms. Coley to plead guilty?
No, Your Honor.
I'm sorry. I'm having a hard time hearing you because they're kind of loud out here.
Okay. I asked the attorneys whether they were aware of any promises, threats, or inducements other than the plea bargain to get you to plead guilty.
No, Your Honor.
No, Your Honor, I'm not aware of any.
Okay. Ms. Coley, has your attorney promised any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Murphy, would you like to establish the factual basis?
Yes, Your Honor. And I just wanted to clarify, she is also pleading to count 2, resisting and obstructing an officer.
Okay, I apologize. Thank you for that. So let me ask just a few more questions. Ms. Coley, you understand with respect to count 2, you'd have all the same rights that I've already explained to you?
Yes, Your Honor.
And if you plead guilty to count 2, you're also giving up all of those same rights, just as I've described?
Yes, Your Honor.
How do you want to plead to the charge that on or about October 16, 2022 in City of Adrian, Lenawee County, Michigan, you did commit the offense of assaulting, resisting, obstructing a police officer?
Guilty.
Has anyone made any threats or promises to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept that plea, all of the same things apply, that you're giving up any and all claim that the plea was given as a result of threats or promises that weren't disclosed to the court on the record today?
Yes, Your Honor.
And has your attorney promised you any particular sentence with respect to that offense?
Yes, Your Honor.
He has promised you a sentence with respect to that offense?
Yes, Your Honor.
Can you hear and understand me all right,
I
Ms. Coley?
can't. The officers are being loud out there. I can't. They're.
Can you call the jail and see if they can refer to them, because it's too loud. She can't understand this.
I am telling Judge Olson, Miss Cassie Cooley is having a hard time understanding the judge, so it's very loud in there. Can we get her moved to a different room where she can understand? It's the only room you have for her, and she's a female. That's the only room you have for her.
Then the office was outside to not make so much noise.
But then the judge said
Wasn't
the
a
officers
problem.
staying outside her room need to not make so much noise because they're prohibiting her from understanding and hearing the judge speaking. All right, thank you. Bye.
Right, is it any better yet, Ms. Coley?
Yes, Your Honor. Thank you.
All right. Okay, so you had just indicated that you wanted to plead guilty to the assaulting, resisting, obstructing a police officer charge. Is that correct?
Yes, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence would be with respect to that charge?
No, Your Honor.
Is it your own choice to plead guilty to that charge?
Yes, Your Honor.
All right, Mr. Murphy, would you like to establish the factual basis?
Yes, Your Honor. Thank you. Ms. Coley, can you hear me okay?
Yes.
Okay. Now, were you indeed in the city of Adrian, the county of Lenawee, the state of Michigan on October 16th of 2022?
Yes.
And on that date and time, were you at the Myers retail store?
Yes.
And were they open for, was it just during regular business hours? Were they open to the public?
Yes.
And while you were there, did you attempt to take without paying for some merchandise, some items that were up for sale?
Yes.
And was the value of those items $287.15?
Yes.
And did you have previous retail fraud convictions in 2019 and a larceny in 2011?
Yes.
Okay, and during that incident, when you left Meyer, did a police officer try to tell you to stop?
Yes.
And you knew it was a police officer of the Adrian City Police Department?
Yes.
And did you fail to stop and try to run for a period of time?
Yes.
So you would acknowledge that you failed to comply with the lawful order of that police officer?
Yes.
Your Honor, I think we've satisfied the factual basis.
Satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor. Thank you.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Coley has had full knowledge of her rights. She's had competent counsel. I will refer the matter to the probation department for a pre-sentence investigation. And we can set sentencing for September 25th at 8:15 a.m. Ms. Coley, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir.
Okay. I'm going to adjourn the contempts to the date of sentencing since one of those deals with the tether issue.
Thank you, Your Honor. And may we address bond?
Yes, go ahead.
Your Honor, I'll ask the court to consider allowing Ms. Coley to be released to an inpatient treatment facility. She does have a sentence she's serving down in district court from, I believe, Judge Shather, and I believe Judge Shather was open to allow her to be released to an inpatient. I think that given Ms. Coley, her situation, that her criminal behavior is stemmed from this addiction that she has, issue that she has. We do understand the concerns for flight risk the court may have. You know, I mean, quite frankly, I guess, you know, the situation is what it is. We can't deny what's occurred in the past, misstates, but Ms. Coley is expressing a strong desire to take advantage of an opportunity to go into an inpatient. She's been making use of what she can at the jail as well, to try to, you know, help her situation. As the court just described to her, the plea offer and anything that we had discussed in regards to it would be off the table if she was to fail to uphold her end of the bargain, which in this case, again, we're asking the court to allow her to go to an inpatient in order that she successfully complete it. We're not asking the court to just allow her to be released on her own, purely on her own. So we'd ask the court to consider amending her bond again to allow her to be released to an inpatient.
Ms. McClure, do people have any position on that?
No, Your Honor, you're as familiar with the history of this case as we are, so I would leave it in the discretion of the court.
Okay, I think Ms. Coley has been at the jail for about 6 weeks now. I would note that she did have a history of appearing before the failure to appear. I think she attended a fair number of pretrials before that. There does appear to be a substance abuse issue happening here, and so I would be willing to modify the conditions of her bond to allow her to be released to a residential inpatient treatment facility. And so I will make that modification.
Thank you, Your Honor.
Is there anything else we need to address with Ms. Coley's case today?
If the judge could remind me of the sentence date, and then if Ms. Coley is in an inpatient facility, she would just likely waive her in-person sentencing to be sentenced via Zoom from that facility.
And we'll make sure that she has our Zoom information before she would go to the treatment facility, and that date was September 25th.
Okay, thank you.
Probably if maybe there's a way we could make sure probation has a chance to interview her first before she goes also.
I'm sorry, go ahead, Mr. Murphy.
I was going to say, Your Honor, I'm sorry that I have to let Judge Shather's court know that the bond has been changed, and so it's going to be a couple of days at least before that anything gets changed in regards to what's going on down there.
All right, so I will add to that then that she can be released after her pre-sentence investigation interview to a residential inpatient treatment facility, because it can be.
Thank you, Your Honor.
Just to make sure we get that done and we can do the sentencing.
Thank you.
Yeah.
All right, is there anything else we need to address with the case today then?
Nothing further from the defense, Your Honor. Thank you.
Nothing on behalf of the people.
All right, Ms. Coley, you can let the officer with you know that you're done with court for today then.
All right, thank you, Your Honor. You have a good day.
Thank you, you too.
Thank you, Ms. Coley. You have a good day. Your Honor, that was all that I had left on my docket. I was going to log off now if that's okay with Your Honor.
Okay, thank you, Mr. Murphy.
Everyone have a good day.
And let's see, so Mr. Brandon, I have Ms. Underwood here now, so I'll put you in a breakout session with her. Ms. Underwood, are you there? Ms. Underwood, if you're there, your microphone is muted. I'll need you to unmute. Okay, so Mr. Brandon, as soon as I'm sure that Ms. Underwood is there, we have some verification, I'll set up that breakout room. Mr. Lyons, are you ready to proceed with Mr. Fenton?
Yes, I am. Thank you, Judge.
Okay, so this is file 18-19189-FC, People versus Michael Davis Fenton. We are here today for a status conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure on behalf of the people.
May it please the court, George Lyons on behalf of Mr. Fenton.
Okay, so where are we with Mr. Fenton's case today?
Your Honor, if I may, I'd ask the court to set the matter for a final pretrial. I'd like to approach the people about a possible resolution.
Okay, Ms. McClure, do you have anything we need to address?
I would agree, and I believe it would just be a pretrial, not a final pretrial, because there's no trial date.
Yeah. Yeah, so we'll just set one more pretrial, and then if it hasn't resolved at that time, we'll set it for a trial.
Sounds good. Thank you, Judge.
Looks like I can do September. Let me do one more on September 3rd, if that works.
Third.
Let me double check that I'm in that day. Yes, that works for the people.
I believe that would be a good date for me. I'll just double check, Your Honor. Yes, if I may appear by Zoom, Your Honor.
Yeah, Zoom is fine.
Thank you, Your Honor. The 3rd of September works good for me. Michael, as soon as I talk to the prosecutor this week or early next week, I will come up to see you.
Okay, thank you, sir.
Your Honor, thank you. Phoebe, always a pleasure.
Thank you.
Thank you.
Thank you. Mr. Fenton, you can let them know you're done with court for today.
Yes, sir. Thank you.
All right, Ms. Underwood, are you there?
Judge, I don't believe I have anything else on your docket, unless there's anything the court's aware of.
No, I think that is it. We just had this front of the court.
Okay, thank you.
Thank you.
Yeah, no more pleas then.
Correct.
Thank you.
Thank you. Ms. Underwood, are you there?
Hey, Sarah, it's Ryan Judges. So we're looking for Rhonda, and we thought we had her on Zoom, but she can't hear us, or she's having issues, or? Okay. All right, thank you. Bye.
Okay, so Ms. Underwood, I'll put you in a breakout session with Mr. Brandon right now. Okay, Ms. Underwood, do you know how Mr. Clark would like to proceed?
Yes, Your Honor. I've spoken to Mr. Clark. What is the current arrearage, Your Honor? I
Current
know
arrearage is
back in 2023, it was 6,000.
Currently $18,796.14.
Wow. Okay. Mr. Clark, at this point, Your Honor, lost his job and does not have any payment that he can provide today. Under the circumstances, he wishes to plead guilty, Your Honor.
Mr. Clark, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are entitled to have any witnesses against you appear at your trial if you were to have one. And you would have the right to question them. You or your attorney would have the right to question them under oath. Do you understand that?
Yes, I do.
You are entitled to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes.
You are not required to say anything or testify at your trial, and nobody can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, I do.
On the other hand, do you understand that you're entitled to testify at your trial if you wanted to testify?
Yes.
How do you plead to the charge that you failed to pay child support to the best of your ability up to the amount ordered?
Guilty.
And how do you plead to the charge that you failed to appear for a contempt hearing on that on July 14th, 2023?
Guilty.
Sorry, that was July 10th, 2023. Okay, so Mr. Clark, you have a current child support obligation through the Lenawee County Circuit Court, is that right?
Yes.
And that's $591 per month? I'm sorry, if you answered, I wasn't able to hear you.
Yeah, I can hear you.
You understand that you have a monthly child support obligation of $591?
Yeah, the last time I paid it was like $230-something a week.
Okay, do you understand, do you agree that the current arrearage, the amount that you're behind, is $18,796.14?
Yes, I do.
And the last payment that you made was January 21st of 2025, is that correct?
Yes, and I've given her money hundreds of times that she doesn't account for. I can prove payment, me giving her payments.
Okay, so Mr. Clark, if you don't pay it through the friend of the court and she doesn't.
Yes, I understand that. Yeah, I get that.
There was a hearing back on July 10th of 2023 because there was a contempt process already started. And do you agree that you did not appear for that hearing?
Yes.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Clark has had full knowledge of his rights and he's had competent counsel. Ms. Underwood, is there anything you'd like to say on behalf of Mr. Clark before the court passes sentence?
Your Honor, I would say that Mr. Clark needs to do a number of things. Number one is if his first stop when he leaves jail should be the front of the court office to have a review. And number two is that he needs to get employment and start an income withholding and then hope that this has not attracted the attention of the Attorney General's office, which I'm kind of surprised it hasn't. Because he does not want a felony charge. I would ask the court to consider releasing Mr. Clark to make payments, Your Honor. If not, if the court does give a jail sentence in this matter, I would ask that there be a paying out of some amount so that if anyone does have any money for Mr. Clark, he can get out.
Mr. Clark, is there anything you'd like to say on your own behalf before the court passes sentence?
I'm sorry, I couldn't hear you.
Is there anything you want to say on your own behalf before the court passes sentence?
No. Although she is right, I would like to have a review if that's possible.
So in order to do that, you have to go to the friend of the court office when you're released and file a petition.
Okay.
All right, so it's going to be the sentence of the court that you serve 30 days in the Lenawee County Jail. Were you arrested yesterday?
Yes, I was.
Yeah,
I turned myself in. No, I turned myself in yesterday.
Okay, you have credit for 1 day served. Obviously, it's what the court is after here is payment of child support. So if you're able to pay the amount of $2,000, you can be released from your sentence early.
Your Honor, we also need a good address for him.
Where's your current address, Mr. Clark?
215 West Airport Highway, Swanton, Ohio. But I won't, I mean, I can give you that address, but I won't be living there when I get out.
You'll need to update your address when you get out then.
Okay.
All right, you can let the officer with you know that you're done with court for today.
Yes, sir.
Okay, thank you. I think we're all set then.
Thank you, Your Honor.